Legal terms that start with the letter A. To abscond is to secretly travel out of the jurisdiction of the court or to hide in order to avoid legal process. Absentee, a person who has disappeared or whose whereabouts are unknown. Access, typically referring to family law cases. This is the right of a party to spend time with the children on a regular basis and to receive information on the children's health, education, and well-being. This is compared to the terms custody or custodial parent and visitation. The accused is a person or company charged with a crime or a defendant in a criminal matter. An acquittal is a finding of not guilty in a criminal case. An act is a law passed by provincial or federal legislatures. The court can also be directed to look at these acts or laws in what are sometimes referred to as authorities. An example of this would be an accused person asking a judge to look at the Evidence Act in Ontario to decide on the admissibility of a piece of evidence. In another example, if you were suing a school board in a civil matter, you may look to the Education Act in Ontario as an authority on whether a teacher or principal had a duty owed to you, a lack of which could result in a negligence finding. An action is a legal proceeding in a civil case. A family court case can also be called a family action or a family matter. Just a side note, family court is considered civil law. Actus reus is Latin for guilty act. It's a voluntary action or omission that, when intentional, results in a criminal offense. In criminal law, a guilty act must be usually accompanied by a guilty mind, or mens rea, for there to be a conviction of guilt. An adjournment is a postponement of a court hearing to another date. If you're in custody, this may be called being remanded. Admissible evidence is evidence that may be received by a trial court to aid the fact finder, either the judge or a jury, in deciding the merits of a controversy. Each jurisdiction has rules of evidence to determine questions of admissibility. Because there are rules for admissibility, if something is admissible, that means it's typically in compliance of exclusionary rules or rules of that evidence being excluded. An affidavit is a written statement or declaration of facts that are sworn or affirmed to be true. An affidavit of service is simply an affidavit certifying that a document has been served on somebody. An affirmation is a solemn declaration made by a person to tell the truth. Lying in an affirmation is perjury, a criminal offense. Being affirmed or giving an oath is basically a promise to tell the truth. When you swear, or it's also referred to as affirming or commissioning an affidavit, you can swear before God or affirm to tell the truth. Aggravated damages are often not awarded, but when they do apply, it is where the injury or damages onto a person are from a wrongdoer's behavior. Examples of this in law can also be found in criminal law, just referring to the term aggravated. For example, aggravated assault is a more heinous or horrific or terrible form of assault compared to just a simple assault. The same is true for aggravated damages. Arbitration is a process that takes place outside of court, where a neutral third party, selected by the disputing parties, makes a decision on the issue in dispute, much like a judge, except it's binding, meaning it's a final decision. A judge's order, on the other hand, can be appealed. Amicus curiae is Latin for friend of the court. If you're representing yourself, you may hear this more often than not. And it is essentially a lawyer who assists the court during the course of a hearing to represent the position or interests, usually at the court's request. An example may be in a sexual assault case, where the court may order that a self-represented party cannot cross-examine a complainant or witness personally, and a lawyer must do so on their behalf.